You have the right to remain silent, but we'd prefer if you didn't.
Spinning the law, spinning the law.
This is Malzberg's
Spinning the law,
Spinning the Law
spinning the law, spinning the law.
with attorney Kendall Coffey.
All right, ladies and gentlemen, we are efforting Kendall Coffey as we speak, and we hope to be joined by him, and we go spinning the law. We have a lot to talk about. One item not on the docket, if you will, with Kendall, and I haven't mentioned yet because there's been so much breaking news and so much discussion of the Supreme Court decisions. This does not involve the U.S. Supreme Court. This does, however, involve the New York State Supreme Court. Now, you may recall all the hullabaloo. I like that word, hullabaloo. Anyway, I also like brouhaha. Yes, brouhaha. That's a baseball fight and a melee, although melee has other implications as well. Nonetheless, let's get back to to what we're talking about here. And this is the New York State Supreme Court, which is banned, not banned, but has knocked down for the final time the attempted ban on large soft drinks, large sodas, which Mayor Bloomberg, the mayor of New York City at the time, tried to institute, and the courts have knocked it down. Safe and legal, and will always be, hopefully, to drink as big a soda as you want in New York City. Soda as you want in New York City. So we got that in. Now we say hello to Kendall Coffey. Hello, sir.
Hey, Steve, how you doing today?
I am good. I'm sorry we picked such a vacant, barren time with no stories, no news to convene today.
Well, we got a lot of things. Although I missed the music, Steve.
No, well, yeah, it did play. I could vouch for it. It did play.
Oh, okay.
And it went something like "Spinning the Law," "Spinning the Law," as you well know. You just wanted me to do that, but it did play.
I did.
All right, let's get right to it, and let's start with the 9-0 decision on Obama's recess appointments. Of course, they kept the right for recess appointments to exist. Which some, like Tom DeLay told us earlier, believes it's unconstitutional. But that aside, what they said was he abused his authority in making those 3 specific recess appointments. So I ask you about that, and what does this mean going forward, Kendall, for the 3 board members who were appointed? Are they now out automatically? And what about decisions that they voted on that have been implemented? Do those get reversed?
Well, a couple questions. Let's start out with what happens when somebody is acting in a position of public authority, and then later on, for whatever reason, they're unseated because of principles that said they weren't supposed to be holding that position. There's a de facto principle which says, in effect, that since they were a de facto fill-in-the-blank judge, mayor, legislator, that their public acts will still generally be held to be valid. Now, that hasn't been thoroughly tested in the unique context we're talking about, but that's the general rule. And the reason is you don't want to simply undo everything that's been done. Let's say turns out that somebody who was elected judge didn't meet the residency requirements. They were sitting as a judge for a year and a half till it got sorted out by the courts, or that they weren't properly elected. The law doesn't want all of that to be undone and to try to sort of unscramble the eggs. In terms of what it means going forward, I think it's going to be a very limited power. You're going to have true recesses in the sense that it is an actual recess of the Senate, which is what the founders intended in the first place. It's not going to be sort of a brief gap in the schedule of 3 days, which was the issue tested here. And it's got to be a vacancy that arises during the recess, not
right.
One that was hanging around for a while before the Senate goes into recess. So the power is there. It's good, but it's going to be much more limited than the way it was being applied in the last few years.
Very interesting. All right, now this other decision, also 9-0. Wow, when's the last time you had 2 big decisions like this, and they're both 9-0? On the perimeter, the buffer zone, if you will, under the Massachusetts law, which kept protesters 35 feet back from the abortion clinics or abortion centers because they didn't want to have these people harassed, but it became a free speech issue, and the court overwhelmingly, obviously unanimously concurred.
Yeah, I mean, there are three unanimous decisions in the works. We might have a chance to talk about cell phones as well. But in this case, I mean, you and I had the privilege of talking about a few of these decisions where they come out very strongly in favor of the First Amendment. So when you create any kind of limitation on the right of protesting, and we're not talking about violent protests, we're not talking about protests that otherwise break the law, but protests where somebody's saying, I disagree with what's going on inside that building. The Supreme Court's going to be pretty protective of the right to protest. That's kind of what got our country started in the first place. And the court found unanimously that sort of this 35 no First Amendment rights zone was unconstitutional. There was a dissent, not a dissent, there was some disagreement saying that the court should have gone even farther than they did because they left intact, for example, a Colorado decision a few years back that said very close to a building you could have sort of a personal space zone of, say, 6 feet, where you don't get any closer to a person than 6 feet if you're very, very close to the clinic. So that law still exists, but the general statement of First Amendment was emphatic, it was unanimous, and it's not the first time we've seen very strong positions taken on the First Amendment by this court, whether you talk in terms of protests near, for example, the funeral of an Iraqi war veteran, we would call that case, and even campaign spending. This court, part of the legacy of Chief Justice John Roberts, is going to be a very, very emphatic pro-First Amendment legacy.
And as you mentioned, Kendall, the decision that was rendered earlier in the week on cell phones, that police officers cannot routinely look at a person's cell phone, look into what's in there upon making a stop. They have to get a warrant under normal circumstances. That speaks to the right of privacy, and that also was 9-0.
Not 9-0. Although they quoted an interesting statistic I was going to ask you about. They said that 12% of Americans apparently use their cell phones in the shower. They were talking about how indispensable cell phones are to modern life. So I haven't taken mine in the shower yet, but who knows? Maybe when they have waterproof cell phones, we'll all be doing it.
Well, let me tell you something. They do have waterproof cases. Supposedly they're waterproof. My son has one, although when he dropped it on the floor and not from a high distance, it ruined the screen of the cell phone. So I guess it's better to stick it underwater than to drop it. But anyway, go ahead.
Yeah, well, instead of singing in the shower, we can have maybe business conferences. Hopefully no video features.
Right.
But you know, what they said kind of, I mean, it does make sense, doesn't it? I mean, a cell phone isn't like, you know, some kind of simply a physical object. And as you know right now, when you're arrested, the police can tell you to empty out your pockets.
Right.
And a big part of that is safety concerns for the officer. I mean, they've got to find out what you're carrying when you're arrested. So it's one thing for an officer to say, okay, you've got a cell phone. But it's another thing to get inside and extract all the information without a warrant. And I think by and large, you know, the law enforcement community isn't thrilled with this, but they're going to be able to live with it because they can hold the cell phone, they can basically quarantine it, preserve it, I think, temporarily, and get a warrant. And in some systems, you can get warrants really fast. You do it sort of almost electronically, or you get a magistrate on the phone, and you can get them pretty fast.
And there are exemptions, I believe, if it's a terrorism case or something of that nature. I believe there are some exemptions. Now, before we run out of time, Kendall, let me ask you, this Boehner lawsuit, let me ask about standing. Is he going to get standing, and whatever other congressman he brings on board, are they going to get standing? Do they need a majority of the House of Representatives to get standing before a judge to go ahead with this lawsuit against the president?
Well, they, you know, I think the courts are going to look for any number of reasons not to decide that. One of them is going to be the doctrine of political questions. Another could very well be standing. You know, the Speaker's frustration in a way is understandable. There have been a number of executive actions of non-enforcement that we've talked about on the show, non-enforcement with respect to everything from Obamacare to certain immigration issues, where they simply say across the board, we are declaring that we're not going to enforce this part of the law, even though we're the executive branch, we're supposed to enforce the law. There are other examples, too, that he's citing, but I think what the courts are going to do is say, oh, you got this kind of fight between the House of Representatives and the President of the United States, we the judiciary,
Are
the
out.
third branch is going to be OUT out of this one.
Yeah,
You
because
guys
there
sort it
are
out.
there are provisions in place, whether it's funding, defunding, or the I word. I mean, it's built into the Constitution. There are ways to remedy it. But anyway, Kendall, great to talk to you, sir. Thank you for being with us. Always appreciate it.
Hey, thanks so much for inviting me, Steve.
My pleasure. Kendall Coffey, ladies and gentlemen, as we were spinning the law. By the way, cell phones in the shower? I never heard of that. Never heard of that at all. We're coming back, ladies and gentlemen, and don't go away. Up next, you know it, you love it, you got to have it. It's the one and only segment that we call Gimme 5, and this is going to be part 2 of the Gwen Ifill interview with Hillary Clinton, where we go over pieces of it, and this is a wide-ranging portion. Don't miss it, only on Newsmax Television.